Michael Jackson's former housekeeper says children ran wild at his Neverland estate and would sometimes stay in his room. She testified on Thursday about serving dinner to Jackson and observing 3 children who appeared to be intoxicated. Well, joining me from our Los Angeles bureau is attorney John Patrick Dolan, a certified specialist in criminal law. Now, Mr. Dolan, we've got a picture of really a number of children or a number of young boys with whom Jackson had a close friendship, to whom he regularly served alcohol. Is that damning in itself?
Well, I don't think it's damning in itself. I mean, it's probably an example of adolescent exuberance. Young adolescents like to, if they can, have a chance to drink some alcohol, and I have a feeling that that probably happened. I think the interesting thing to get out of it is only the accuser in this case is suggesting anything happened besides the drinking of alcohol, and that's really going to be the issue in this case. Did molestation happen, notwithstanding the fact that there might have been some alcohol in the territory there?
I mean, certainly what's being described is pretty odd, isn't it? That these children stayed there without their parents, that they, on one occasion under cross-examination it was revealed that the accuser actually trashed his guest suite. I mean, all very strange sets of behavior, really, not least by Jackson himself.
Well, I think you're right, and I think it's probably attributable to the age and the hormones of the young boys that were involved. But, you know, every time you look at this, you have to ask yourself, is this just young boys having fun with Michael Jackson and sort of cutting up? Or is this some sort of nefarious plot wherein Michael Jackson is trying to groom some young boys for molestation? And as I said, other than this particular accuser in this case, nobody else has said it went any further. So it really brings into question the credibility of the accuser and, of course, of his family.
The other thing I'd like to ask you about is the extensive stash of pornography, which was found at the Neverland Ranch. Some of it seems to have involved titles such as Barely Legal and Teenage, which apparently show young women meant to appear underage. Is that damning in itself, or is the fact that it was mostly, only perhaps 1 or 2 exceptions, concerned with women, perhaps in a way a counterindicator to Jackson's alleged interest, sexual interest in young boys?
Well, you make a very good point. It's hardly consistent with the allegations in this case to suggest that they were looking at girly magazines, but I have to say, all of the things that they seized at the ranch were legal. They just might not be terribly appropriate. But I remember my young days in age 13, 14, 15, and frankly, many of my friends and I were looking everywhere we could to get one of these magazines. That didn't mean that we were being molested by anyone. So I'm not quite sure that there's a connection here between these magazines and the actual molestation that's charged. Of course, the prosecution wants us to believe that you add alcohol and girly magazines, and there's only one more step until you get to molestation. But it's interesting to see if they're going to make that logical leap based on evidence.
Now, one of the things that is very intriguing, to me anyway, being much more familiar with the British criminal system, is the fact that the judge is to hold a hearing next week to determine whether prosecutors can tell juries about a 1993 case in which another young boy, or then young boy, accused Jackson of sexual molestation. That was all settled out of court. Nothing was ever admitted. But what is being talked about is whether the prosecutors can call this 1993 accuser as a witness. Is this really allowable? Actually in this case, a previous non-conviction, is that really allowable under Californian criminal law?
Well, it is under certain circumstances. There's a section in the evidence code in California called 1108 that was added to the evidence code in the mid-90s that essentially says this: if you have prior conduct that is a prior crime or a prior act that could be charged as a crime, and if it tends to show plan, scheme, or design or motive, then you may, under certain circumstances, be able to bring this into evidence, but you have to weigh the probative value compared to the prejudicial effect. In this case, there was no crime charged, there was no conviction. There's an interesting question about whether or not the acts are even similar. So I think it's going to be a hearing that's going to have great attention focused on it, and frankly, I don't think the judge is going to let this in based on what we've heard so far. But I'm from the defense point of view, and I could be wrong about that. If it comes in, it's pivotal, it's critical, and it will probably turn a 3 or 4 month trial into a 1-year circus.
And just very briefly, let's be clear on one thing. That hearing would be held without the jury present, right?
You're absolutely right, but one thing you should note is that the hearing will be held without the jury present, but the actual witnesses, the actual alleged victims from prior acts, will have to testify, as I understand it, before the judge will make a ruling on whether they can testify before the jury. So we'll get a preview of what they have to say before the jury hears it, if they hear it.
John Patrick Dolan, expert in Californian criminal law, thank you very much indeed for joining us live this morning.
Pleasure, Charles.
Let's get the very latest on